Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every other Friday, and sometimes occasionally on a special Thursday, is Alex Ooley from the Ooley Law Offices in Indiana. Alex, thanks for coming along today, man.
Great to be with you, Paul.
Last Thursday we had you on, and it wasn't your week to be on, but because we had the Bruen decision come down, we had you on to talk about that. We've got a little bit more to talk about Bruen, and we've got a lot more legal stuff to talk about. Before we get into that, I want to let everybody know a couple things. If you want to get a comment in, especially if you want to ask Alex a question, a legal or a constitutional question, get your comments in early. I can't always get all the comments on the air, but I get all that I can. Just comment on either the Facebook or YouTube video, or if you have Twitter, you can tweet with the hashtag Bullet Podcast. I'll get your comments up and on the air if I get time. Also, especially today, I want to say that this show is intended for educational and entertainment purposes only. Nothing Alex or I are about to say is to be construed as legal advice. So, get that
exactly.
out.
This is educational only.
Yes. So, before you do anything like, anything radical, I would consult an attorney in your local jurisdiction first.
Unless you're interested in becoming a test case.
Yes. Right. Yes. So let's dig into the Bruen decision a little more, Alex. What I want to start with is this. Thursday, this decision came down and the meltdown started. Friday, there was a decision from the Supreme Court as well, and I'm going to put this is a gun show. We're going to be talking about gun topics, but I've got to bring this up to put the other in perspective. On Friday, there was a decision that overturned Roe versus Wade from the Supreme Court. The meltdown continued, but the difference was, from what I noticed, immediately when that decision came down, the next day, the South Dakota, where I live, has I guess it's called a trigger law, and the next day abortions were illegal in the state of South Dakota, and so with very few limited exceptions, and I do not want to discuss abortions, but why, when they decided Bruen, didn't New York, New Jersey, California, Hawaii, and the other may issue states have to start issuing permits the next day?
Yes, so that's a great sort of distinction to make between the two cases, because in Bruen, the court overturned a law that was in place, and that was the law in New York that required a special showing, a showing of a special need to obtain a license to carry a firearm. In the abortion case, there were a number of states throughout the country who had these laws that were triggered upon the Supreme Court's decision in the Dobbs case that went into effect basically immediately or shortly after the opinion in the Dobbs case to outlaw abortion. And the difference here is that states like New York that have bans on or that have gun control measures in place, they're not anxious to get rid of those gun control laws. They would like to restrict the right to keep and bear arms as much as possible, and they're not going to get in any hurry to allow their citizens to exercise their freedoms, their rights. So they're going to go down screaming, basically, before they get rid of their gun control measures in states like New York and Hawaii and Connecticut and California and New Jersey. But they will have to come into compliance at some point. They're just not going to do it quickly. Whereas in the states, with respect to the abortion issue, they were putting laws into effect rather than repealing laws, because the Supreme Court didn't outlaw abortion. They just said that Roe was overturned, that it's an issue for the states. They're returning that issue to the states, And so it's a different sort of measure that states are dealing with.
Okay, makes perfect sense. Then it was later. I think it was Tuesday of this week. We had more cases. We had 4 cases total that were out of the Supreme Court were vacated and returned to the district courts, and now these weren't a direct overturning, like, or a direct saying that these cases are overturned right away. They were vacated, meaning I guess, oops, you made a mistake, or gee, let's try this again, but they're not gonna accept the same ruling when the cases come back, right?
Correct. So there were 4 cases, as you said, and the court granted what's called a GVR. It's an acronym that just simply means they granted certiorari, and certiorari means review. It's a fancy term for review. The Supreme Court granted review. That means they're going to consider it. Then they vacated it, which means they overturned the ruling from the lower court, and then they remanded the court for they remanded the case for reconsideration. So basically, they said your opinion from the lower court, it's not consistent with our recent decision in the Bruen case. We're going to vacate your opinion, send it back to the lower court for reconsideration in light of the guidance that we've given in the Bruen case. So they expect the lower courts to reconsider these cases with the guidance that the court has outlined in the Bruen decision.
Now, the Bruen decision, as we talked about several times leading up to that decision, they did go with the absolute most strict level of scrutiny you can get, and that's history and tradition. Am I saying that right? In which you don't. It goes even beyond strict scrutiny. You have to look at what was was happening at the time of the Constitution. You have to look at the traditions of how things were implemented. And is there any way that things like Maryland's assault weapon ban, or the 10-round magazine limit in New Jersey, or no open carry in Hawaii, I can't myself, I'm not an attorney, but I can't see a way where any of these things can stand coming back?
That's right. I agree with you, Paul. I think there may be some lower courts in the more liberal districts that attempt to reconcile the text, history, and tradition of the Second Amendment with gun control measures, but I think it will be a futile effort. Those cases will likely be appealed. If they get to the Supreme Court, I think the Supreme Court would overturn those gun control measures. I just don't think that these courts may find some history that's consistent with these gun control measures, but certainly not on balance. I think history lends itself against gun control.
Next point, and again, folks, please do get your questions in. Comment on either the Facebook or YouTube video. But next question I wanted to talk about with you, Alex, is there are a number of states going specifically towards the New Jersey and California magazine limitations. There are a number of states. Washington, it just went into effect today. There's a 10-round magazine limitation. New York has they started off with a 7-round limit. Now it's 10 rounds. That's going to be just as affected as New Jersey and California is by these, right? Especially Washington's in the same district as California, to the Ninth Circuit.
Right. Yeah. So just for a little background to explain why, I suppose, in 2008, the court decided Heller, which recognized an individual right to keep and bear arms in the home. And that was applicable only with respect to Washington, D.C., which was a federal enclave. And because remember, when the Bill of Rights was adopted, it was only meant to apply to federal government action, not to state government action. And in 2010, through a process of what the court has called selective incorporation, the Supreme Court decided the McDonald case, which said that not only does the Second Amendment protect an individual right, not some collective right, it's a right that protects rights of individuals against state government action, not just federal government action. And then in the Bruen case, 12 years later, the court said it not only protects an individual right to keep and bear arms in the home, as we learned in Heller, it protects a right to keep and bear arms in public. And that right applies to not only protect individuals from federal government action, but also state government action. And that includes California and Washington equally, all states equally. So those states, especially as these cases are decided in their respective jurisdictions. So if they're in the Ninth District or the Ninth Circuit or the Seventh Circuit, as those cases are decided, it will apply to the states within those circuits. But the Bruen decision, as the Heller decision and the McDonald decision, all apply to every state.
Okay. All right.
One thing I'd like to mention too, Paul, with respect to text, history, and tradition as the standard of review for Second Amendment or for Second Amendment challenges. So I think it's important to point out that the court provided quite a bit of guidance about how that should be applied. But one thing that Justice Barrett, Amy Coney Barrett, brought up was, what period of history do we look to? And the court in Bruen said that it didn't matter in the Bruen case really what period of history you look to. This special need requirement in New York would fail under a text, history, and tradition analysis. But that's going to be an issue that comes up in a lot of these cases in the lower courts, and that will probably need further guidance from the Supreme Court at some point. What period of history do we look to? And that's going to depend on the nature of the gun control measure that's being challenged.
Okay. So they wouldn't automatically go back to 1790 when the Constitution was ratified. It could be later that they could look at for their text, history, and tradition.
Yeah, so there may be some gun control that may have been acceptable through a period of history after the Civil War, for instance, after Reconstruction, that may have not been prevalent at the time of the founding, at the time of the Revolution. So there's going to be some nuance there in terms of what the courts look to in terms of the history. It's going to be a pretty interesting analysis that courts will have to go through to review these sorts of cases. But like we said earlier, I think these magazine capacity bans, these assault rifle type bans, I think they're going to be overturned.
Well, in my experience, gun control is a fairly recent thing in our history. We really didn't start seeing it until the 1960s. Mm-hmm. And so there's, almost 200 years before that of text, history, and tradition of not a lot of gun control.
Yeah, that's right. And really, one of the first gun control measures was the National Firearms Act of 1934. Mm-hmm. And a lot of anti-gun folks point to the Miller decision that analyzed the constitutionality of the National Firearms Act. But I think the National Firearms Act, personally, I believe it's unconstitutional. Whether or not the court will ultimately reach that decision, result, I don't know. I can't say that with any degree of certainty. But one thing I will say that's been overlooked a little bit is the importance of another decision that the Supreme Court recently released about the authority of the EPA.
Yeah, we're getting comments about that. Yeah.
I think that's important because it could have pretty far-reaching ramifications with respect to administrative authority. And that includes agencies like the ATF, who like to govern and place gun control measures on individuals by fiat, basically, without any sort of legislative oversight. And in the Supreme Court case that involved the EPA recently, they said that they couldn't make substantial determinations without basically input from the legislature. So we won't have this. I mean, if we have administrative agencies just putting restrictions, regulations into place without legislative oversight, that's effectively government without representation, because you can't vote bureaucrats out of their administrative agencies.
Right. That's absolutely true. Let me get a couple of these comments in here real quick. Charlie was talking about that West Virginia versus EPA decision will help restrain the ATF as well. And the decision by the conservative court majority sets the stage for further limitations on the regulatory power of other agencies as well. The comment was too long to fit on the screen, but yeah, I've been bringing that up from time to time. I really think that West Virginia versus EPA could be a very important decision coming up in the next several years for us. It could help not just in the gun world, but for people who are like me, who are strongly libertarian / conservative. It could help reduce the scope of the reach of things like the EPA, the Department of the Energy, the Department of the Education Department. A lot of the executive branch could be cut down because of this.
Yes, exactly. I think this case is going to have pretty far-reaching ramifications for lots of administrative agencies, these alphabet soup agencies that have largely unrestricted power without the ability of voters to hold them accountable. And that's I think exactly the opposite of what the founders envisioned.
Roderick asks, do you think that the Bruen case has neutered the court's selective incorporation doctrine that has been around for decades to apply to the Bill of Rights to the states?
No, I don't think there's anything in the opinion that, as he says, neuters the court's selective incorporation doctrine. I think, obviously, there's sort of this debate about how selective incorporation should be applied, whether it's through due process and equal protection or through the privileges and immunities clause. And this is something, interestingly, that Justice Clarence Thomas has opined on quite a bit, but I don't think is affected much by the Bruen decision. And just so people know, selective incorporation, as I said earlier, the Bill of Rights, when it was adopted, was meant only to apply to federal government action. And after the Civil War, there was this concern that newly freed slaves were not having their rights protected. And the court basically it was an act of judicial activism, I believe. And I think selective incorporation is a flawed doctrine. But nevertheless, it's something that has been around for quite some time, since right after the Civil War. The Supreme Court has incorporated, which means simply that they have applied certain parts of the first 10 amendments to apply to the states and state government action, not just federal government action. But they've done that selectively. They didn't just say, okay, now after the Civil War, all 10 amendments are going to apply to restrict the state government action. They applied certain parts of the Bill of Rights piecemeal, little by little over the years. And it wasn't until 2010 that they selectively incorporated the Second Amendment to apply to the states through the McDonald decision.
Okay. All right. And this next question, I'm almost doing this tongue in cheek. I know the answer, but I'd kind of like you to explain the answer. One of the cases that got sent back was the case about there's no open carry allowed in Hawaii. The Supreme Court said, yeah, no, that's not going to work. They sent it back. Does that mean I can now book a flight to Hawaii, strap a Colt Python on my belt, and go wandering on the beach?
Uh, I wouldn't try that if I were you. Or, as we said earlier in the show, this show is for educational purposes and it's not
Right,
legal advice. But if people are interested in being test cases, that would be one way to do it. That's for sure. So one thing that Justice Kavanaugh, actually, in a concurring opinion in Bruen, noted was that this was the Bruen decision was overturning the law in New York, which was a May issue licensing scheme. Uh, and Justice Kavanaugh uh, said that this would not have any effect on states that had shall issue type licensing schemes. And that means that as long as individual applicants for a license met certain objective requirements, that they could not be denied a license by some bureaucrat who was using some arbitrary means to determine whether or not the person should have a license. And the states can still implement certain restrictions and requirements to obtain those licenses, and restrictions on people who want to carry in their state, even if they're out of state. So there will still be restrictions, there may still be licensing requirements, and there will still be reciprocity issues. So even if you have a license in your state,
right.
Hawaii or some other state may not recognize that license. So it won't at least immediately affect those requirements.
So, and I've said many times on the air, I'm allergic to being a test case. So yeah, I had no real plans. I know some people that are going to, when they hear, look, Hawaii got this sent back saying they're going to have to redecide it. I can even picture individuals in my head who would go book a flight to Hawaii just to go walk the beach open carrying. Um,
I would not recommend that, but if people are willing to be test cases, that's certainly up to them.
yeah. Well, eventually we're going to need some,
Yeah,
but it depends on how much time you want to spend in jail and how much heartache you want to go through, because there's going to be some of each.
right.
Uh, Anything else in the legal arena we should be paying attention to that's come up in the past week and a half?
One thing that we've discussed a little bit, obviously, sensitive places is going to be a major issue. It was addressed to a large degree during oral argument uh, in the Bruen case. And the court sort of preemptively said that blanket bans on public places as sensitive places wouldn't be acceptable. But there's sort of this gray area in between. And I think there's going to be a lot of litigation about what areas will be considered sensitive places that might be legitimate, at least that the Supreme Court would view as constitutional limitations on the right to carry in public. So I think there's going to be quite a bit of dispute surrounding that issue. And also, there's this issue about, and we've talked about this a little bit as well, what sorts of restrictions on the types of arms are going to be constitutional. And the court in the Bruen case reaffirmed the common use test, which was established in the Heller case. And so the question with the common use test is whether arms are commonly possessed for lawful purposes. And if they are, then they are presumptively constitutional for someone to possess. And that's why I think these magazine capacity bans, these assault weapons bans are going to be overturned, because so-called assault weapons, the most common one is the AR-15, and it's the most popular rifle in America. And the standard capacity magazine that comes with an AR-15 is 30 rounds.
Mm-hmm.
And that's what a lot of these states are calling high capacity. And really, they're standard capacity because that's the standard magazine that comes with an AR-15. And so I think those will certainly meet the common use test, and those sorts of bans will be overturned.
Related to that a little bit, the one we've been talking about the magazine capacity, and we've been talking about Hawaii. We haven't really touched that much on Maryland's assault weapon ban, but that was one that got sent back as well. That's for anybody. Again, there are more than just Maryland. Delaware just adopted it. The governor signed it just the other day. I'm thinking with these states that are considering assault weapon bans, and I hate the term too, everybody. When the modern sporting rifle bans, these states that have it or are considering it, that can't be great news for them, because in vacating and sending it back, Supreme Court is basically saying we're not going to accept this. You better try again. So, again, I wouldn't, if I lived in Maryland, I wouldn't go be calling Daniel Defense and trying to get them to ship something, because they're not going to, but have hope it will happen soon.
Yeah, and the good news is there's going to be a lot of litigation around these issues. What sorts of arms can be banned, what sorts of arms are in common use, what's a sensitive place that can be restricted, what sorts of restrictions are going to be acceptable under the Constitution. And it's been 12 years since McDonald was decided in 2010, and Bruen was decided in 2022. The good news is that since 2010, the composition of the court has changed. Since then, Justice Gorsuch has joined the bench, Justice Barrett has joined the bench, and Justice Kavanaugh has joined the bench. So the composition of the court is much more friendly to the individual rights and individual liberty in the Second Amendment. So if there are challenges to Second Amendment or gun control laws, I think the Supreme Court is much more likely to take them up, those challenges, to the Supreme Court, and accept those cases for review, so that we won't have to wait 12 years for the next case to come before the Supreme Court. At least I'm hopeful. I'm just speculating in that regard, but I'm hopeful because the composition of the court has changed, whereas before, in Heller and in McDonald, it was a 5-4 decision. So it was a close vote in those cases. And I think the court was reluctant to accept review of Second Amendment challenges because they weren't sure how justices like Justice Kennedy would come out, or Justice Roberts, even in some cases, would come down on certain sorts of challenges. But now the court is much more solidly in favor of individual rights and the Second Amendment. So I think we're likely to see more Second Amendment challenges reach the Supreme Court.
I hope so. I absolutely, especially with the composition of the Supreme Court. Now, yes, we just lost one justice. Breyer retired as of I think it was Tuesday of this week, and then the new justice was sworn in. But honestly, we're just trading one liberal for another liberal. It was a hell no for a hell no. I mean, we're not. There's no change there. So, get this question in here. This is from Pete over at Gun Websites. We hear about test cases to challenge bad rules by ATF, but isn't there a tact where representatives both houses push from their branch demands on the executive branch? Well, what I would say to that is we have three branches of government. They're supposed to be co-equal. We have the judiciary, the legislative, and the executive. That's what you're talking about. Gun Websites is more the judicial or the legislative pushing on executive. Yeah, that happens. For example, I mean, dude, you have to be paying attention to the legacy media a little bit. they've been having January 6th hearings, and almost nobody's paying attention, but it's sure making the legacy media. That's the judiciary pushing the legislative pushing against executive.
Yeah, obviously you've got the balance of powers and separation of powers issues, and obviously there are issues, I think, with administrative law with delegation of powers. So I think, like we talked about earlier with the EPA case, I think that I'm hoping that that case has some far-reaching implications to restrict the arbitrary fiat of these administrative agencies. For instance, I mean, the ATF, the ban stocks with no input from the legislature was just completely out beyond their authority. I don't like bump stocks, but nevertheless, I don't think they had the authority to ban them. And
they're trying to rewrite the definition of a firearm all by themselves.
Right.
And then that's something that needs to be done legislatively, if you ask me.
Yeah.
All right. Well,
agreed.
As usual, we run a little bit over time. Anything you want to plug or anything else we need to pay attention to, dude?
Yeah, I just want to say, obviously I'm from Indiana, as most people know. Permitless carry took effect here in Indiana today, so that's more great news. There's been a lot of great news in the Second Amendment arena recently. It's not all great news. We don't hear a lot of great news often, but we've got the Bruen decision that recognized the individual right to keep and bear arms in public. And in Indiana today, permitless carry took effect. So citizens in Indiana, as long as you are not a prohibited person, no longer have to ask for permission from the state to exercise a constitutional right, which is the way it should have been all along.
I'd like to add that in South Dakota, a law took effect today that starting today, if you want the enhanced concealed carry permits are now absolutely free. There's no fingerprint fee. There's no background check fee. There's no nothing. Once you pass your class, you're done. You have to pay to attend a class, but after that, there's no fee to exercise your rights in South Dakota. So good news from Indiana and South Dakota today. Lots of great laws taking effect. I myself want to remind everybody, come join me at noon Central Time tomorrow. It's going to be the weekend edition of The Bullet. Brooke Cheney, Rick Ector, and Charlie Cook are going to be joining me. Rick's going to be talking about the women's shooting event that's coming up the end of July up there in Detroit. So come join us at noon Central Time tomorrow. Thanks for watching, everybody. Thanks for contributing and commenting, and we will see you